All right, very well. Let's go back on the record with Mr. Williams' case 24 SC 001723. We've taken evidence. I understand the defense has no evidence, state has no evidence, so I will hear argument. I guess Mr. A.D. Wooten, you have the burden, so you can go first and thanks.
Judge, actually, as it relates to the standing issue, they have the burden. I can go first, but I can provide the case on that they have the burden as it relates to standing.
So we do have the burden in regards to standing. However, we have literally argued that now. But the issue here, the state still has the burden to prove before we have to present anything in regards to the bigamy and fraud. So the standing, yes, we do, but I believe the state has the burden for this particular issue we're arguing right now. So, I mean, whatever the court wants to do.
Yeah, who wants to go first? Who wants to go last?
Judge,
I'll hear from everybody at least twice, so go ahead.
Sure. Thank you, Judge. And as Mr. Hoover stated, we've done a lot of arguing the pleadings, so I'm going to try to keep it as succinct as I can and then take any questions that the court may have. But I do want to start at the burden of proof issue as it relates to standing, and I think that's where we start and ultimately where we end, because, and I'm starting with Rakes versus Illinois, 439 U.S. 128 at 131. That's a 1987 United States Supreme Court case. It was adopted in the state of Georgia in Stinsky versus the state, S-T-I-N-S-K-I. That's 281 Georgia 783 at 783-84, and that's a 2007 Georgia Supreme Court case. And the reason I start there is because, again, the factual question before the court today is standing. It's not the substantive of the search. We've already had a hearing on that last December. And so in Rakes and in Stinsky, both the United States Supreme Court and the Georgia Supreme Court have held that where a defendant cannot establish both a subjective expectation of privacy, that is that he himself believed he had a reasonable expectation of privacy in a location, and a legitimate objective expectation of privacy, then he lacks standing to challenge a search. And in both of those cases, the courts have emphasized that as it relates to the threshold standing question, it is the defendant who bears the burden of establishing both the subjective expectation of privacy and the objective, reasonable person expectation of privacy, which has further been defined and fleshed out by the courts to mean an expectation of privacy that society is prepared to accept as legitimate. And so that's really the question. Has the defendant proved by preponderance of the evidence that he had a subjective expectation of privacy, number one, and number two, has he proved that whatever that subjective expectation is one that this court and that society is prepared to accept as legitimate. And so, because it is the defendant's burden, he's got to put up evidence as it relates to both of those things. It's rare that the state gets to say this, but the defendant hasn't proven anything as it relates to either of those factors. He's put up no evidence. Only the state has put up evidence and witnesses. We've heard nothing at all about the defendant's own subjective expectation of privacy, and the state certainly doesn't stipulate to that. And the state, even though the defense has put up no evidence, the state has put up evidence that even if there was a subjective expectation of privacy, that it's not one that this court should accept as legitimate, and it's not one that society is prepared to accept as legitimate. And as it relates to that question of whether or not an expectation is legitimate, there's a long line of federal cases and there's a long line of Georgia cases that talk about what that means. And so, of course, the court knows that means something like, if DDA Winfrey and I are charged together in an indictment and her house is searched, well, I don't have standing to challenge the search of her house. But the courts have over time, given us some information on how this works when the area that is the subject of the search was procured by fraud. And so we've got a whole long line of cases that say a defendant cannot have a reasonable expectation of privacy in a location that was procured by him by fraud. And so I want to start just with the cases and give the court kind of a survey of how that has developed over time. And by far, I would say the broadest area where we see this come up is when a car is directly stolen. You know, a defendant murders someone and steals their vehicle and flees in the stolen vehicle. The vehicle searched, they challenge the search. And routinely, I mean, I think without question, the defendant doesn't have a right to challenge that. I'll give a couple cases that speak to that. First is Burgesson versus the state, Burgeson, 267 Georgia 102 at 105. It's a 1996 case, stolen vehicle. The court held that the defendant had no standing to assert a violation of her Fourth Amendment rights because she had no property interest in a stolen vehicle or legitimate expectation of privacy regarding the vehicle or its contents. And the court goes on to expound on that and say, on the contrary, as one knowingly using a stolen vehicle on a public roadway, the defendant probably was in constant expectation of intrusion by the authorities. And so I'm going to keep moving through the cases, but I'm going to come back to how I think that applies here. Another case, Brisbane versus the state, Brisbane, 233 Georgia 339. At 345, that's a 1974 Georgia Supreme Court case dealing with the stolen vehicle, and the court said that a person in unlawful possession of a stolen vehicle should be in no better position to assert a claim of invasion of his privacy with respect to the search of the vehicle than would be a trespasser on real property. I've cited some other cases dealing with stolen vehicles in the pleadings, and so I won't just list a long line of cases, but they are in the state's motion to dismiss this motion to suppress. But moving on from stolen vehicles, that same rationale has been applied by Georgia courts in other contexts. And so I've got a few that I think are relevant here. First is State versus Del Vecchio, Delvechio. That's 301 Georgia at 560, the 2009 Georgia Court of Appeals case. In that case, the defendant, the search at issue was a hotel room. And so, as this court knows, searches of real property are given a little bit more protection than searches of vehicles in the first place. But in that case, the hotel room was obtained by fraud. I believe, like in this case, a stolen identity and a stolen credit card were used to rent this hotel room that was searched. And the Georgia Court of Appeals acknowledged that legitimate registered guests of a hotel room can have a reasonable expectation of privacy in that room, but one who obtains a room by fraud can have no reasonable expectation of privacy in the room. Like one in possession of a stolen car, mere unlawful possession of a room does not alone warrant a reasonable expectation of freedom from governmental intrusion. And so like here, where the F-350 was procured solely by fraud, and I'll talk about that more in a minute, Mr. Williams can't have a reasonable expectation of privacy in that vehicle that he was driving only because of fraud committed by him. I want to hit a couple federal cases, which I think are instructive because this is, of course, a Fourth Amendment question. The first is United States versus Cayman, Caymen, 404 F 3rd 1196 at 1197. This is a 2005 Ninth Circuit case. A laptop was purchased using a stolen credit card. The laptop was searched without a warrant. Officers found child pornography on the laptop, and then there was a challenge to the search of the laptop. The Ninth Circuit held that because, as the district court below found, Cayman obtained the laptop computer by fraud, he had no legitimate expectation of privacy in the contents of the hard drive. We see no ground on which to distinguish property obtained by fraud from property that was stolen by robbery or trespass. And so if you see, Your Honor, I'm kind of building how this goes from stolen vehicles, trespass, fraud. The courts are treating them all the same way. I also want to touch on another federal case, United States versus Johnson, 584 F. 3rd, 995 at 996. This is a 2009 10th Circuit case. It deals with the search of a storage unit that was rented out through identity fraud, so using someone else's information to rent out a storage unit. And I'm going to read a block quote from that case. The court said, ultimately, what matters is not whether Johnson might have some legitimate property interest in the storage unit, or whether Johnson's interest is one that the Fourth Amendment is intended to protect. Arguments such as those Johnson advances here do not distract us from the fact that a fraud was perpetrated and the victim was a third party. We will not be a party to this fraud by legitimizing Johnson's interest in the storage unit. Therefore, whatever subjective privacy expectation Johnson had in the storage unit were not expectations that society is prepared to recognize as objectively reasonable. Johnson thus did not have any Fourth Amendment rights in the unit and could not expect that the police were required to obtain a warrant or establish an exception to that requirement in order to search the unit. And so, kind of moving to the facts of this case, Judge, I'm going to share on the screen just a little illustration and timeline, because state's position is that there's two areas of fraud. There's the general big picture fraud as it relates to the bigamous marriage, which is the only reason that this defendant had any access to Shirley Strawberry's life. And then there's the very specific fraud of his using her identity to purchase this vehicle. And so I'm going to start with the bigamy. And so I've created kind of a timeline, and there was some testimony that came out through cross-examination that there's been no evidence presented or whatever that there was that the marriage between Mr. Williams and Ms. Strawberry was bigamous at certain points in time. So I created this timeline to kind of illustrate what actually the case is. So starting with wife number one, that's Edith Miller, we know and have proven that they were married on October 22nd, 1985. I asked investigator Ansel on direct if he had tried to find out if there was a divorce. He testified that he did look for a divorce. He could find no indication of a divorce. That same fact was repeated on cross-examination. And I would remind the court, again, going back to where I started, that it's the defendant's burden of proof as it relates to the standing issue. So every single fact that the defendant wants to use in support of his position has to be proven by him. And so the fact that we can't show that there was a divorce, number one, it's up to them to show that there was a divorce that predated any of this stuff. And number two, the only testimony for the court is that there was a search for divorce and it revealed no information. So that's wife number one. Wife number two, Martha Halliburton, and you've seen definitive proof on this, defendant marries her on September 1st, 2001, and divorces her 20 years later on December 29th, 2021. You've also seen definitive proof on the timeline of the marriage between the defendant and Shirley Strawberry. He married her on January 9th, 2015. The divorce was finalized on September 30th, 2024. And so the evidence certainly shows, at least by preponderance, and I would submit by far more than preponderance, that at the time that the defendant married Shirley Strawberry, at a minimum, he was still married to Martha Halliburton. At an absolute minimum, he was still married to her. And we also submit that he was also married to Edith Miller at that same time. I'd also point out that if the court recalls on Exhibit 3, as it relates to the existence of the Miller marriage, on Exhibit 3, this is the marriage license application between Mr. Williams and Ms. Halliburton. The defendant stated there that he had 0 previous marriages. We know that's a lie. And so I think that further supports the circumstantial evidence that the defendant was never divorced from Ms. Miller. So, as I stated, bringing it back, when the defendant married Shirley Strawberry, we know for sure he was married to Martha Halliburton, and the unrebutted evidence is that he was married to Edith Miller. Likewise, the date of the stolen vehicle, or excuse me, the date of the purchase of the F-350, it's a little bit covered up on the screen, but that was January the 28th of 2020, at which time, according to the evidence before the court, the defendant was still married to all three women. At some point, he did divorce Ms. Halliburton. That was by her own doing. But that came after the purchase of the vehicle. So the fact that, the Halliburton marriage had been dissolved prior to the defendant being arrested in the vehicle is of no consequence. The question is, was there fraud being committed at the time that the vehicle was procured? The answer to that is yes. And I would also add in that as Ms. Strawberry testified, she did not know about this fraud until the defendant was arrested and the bill collectors came knocking on her door. So even if that Halliburton marriage was dissolved, I don't see how that has any material impact on the standing question, because as Ms. Strawberry testified, she wouldn't have let the defendant access her life had she known that he was married to these two other women. She wouldn't have married him had she known that he was married to these two other women. And at the time the vehicle was purchased, he certainly was married to at least two or potentially three different women. So that's what I would assert is ground one as it relates to procurement of the F-350 by fraud. Just generally, the entire marriage was fraudulent, and therefore the defendant shouldn't get a benefit based on his relationship with Ms. Strawberry by deceiving her into marrying him. Then moving more specifically into what I would call the specific fraud, being the purchase of the vehicle itself. And the court heard as we just meticulously went through this document, which is Exhibit 1, both from Ms. Strawberry and Investigator Ansel. Again, going back to where I started, it's the defendant's burden to prove that he has standing. He put up no evidence. This is the evidence before the court, and we submit that it shows that the vehicle certainly was procured by fraud. Ms. Shirley Strawberry testified that she has not seen this document until today, that she didn't know that this vehicle was purchased in her name until after the defendant was arrested. He came knocking on, or the bill collectors came knocking on her door. We've walked through the information that was put on this application that shows pretty clearly that it's the defendant who's the one that did this, starting with the telephone number listed for Ms. Strawberry, came back to Alasia Alexander, who is a known assistant, is one word that could be used, of the defendants. She comes up a little bit more in the sex cases, but moving down the line, Ms. Strawberry testified that she would not describe her title as iHeart host Steve Harvey, that she would describe her title as co-host of the Steve Harvey Morning Show. She testified that she doesn't know anyone by the name of Carlos Lamont, but that's certainly not a relative of hers. You heard testimony from Investigator Ansel that telephone number 424-268-0141 came back to Earl Lamont Dunbar, who is, again, a known associate of the defendants. They regularly talk and have regularly spoken on the jail phone. Investigator Ansel testified that he's listened to those phone calls and would describe their relationship as close. So I think it's fair to say that's an accomplice of the defendant who would vouch for him and assist him with this fraud. And then you also heard that Ms. Strawberry doesn't know anyone by the name of Walter Ellis, and that phone number 404-454-5653, that Investigator Ansel spoke to the owner of that phone number, who told him that her daughter had used that phone number in the past, and she believes her daughter is an associate of the defendant. So there's a theme here. All of these people, all of these phone numbers that could be used to verify anything as it relates to the purchase of this truck all come back to the man sitting at the defense table. They all come back to him. Ms. Strawberry doesn't know who any of them are, and she didn't authorize any of it. Just moving briefly through the document, there's 1, 2 times that her signature is used without her authorization, 3 times, 4 times, 5 times, at least 5 times that her signature is used, her name is used without her authorization. She didn't know about it until the defendants arrested in the vehicle. And as she testified, Judge, yes, she's still paying on the vehicle. She said she's paying about $900 a month on the vehicle as of today, every single month. But she's doing that not because she knew anything about this vehicle, not because she authorized the defendant to purchase the vehicle, not because of any reason other than she wanted to protect her own credit from having an impact based on the defendant's crimes. She also testified that she reached out to the financing company, tried to clear this up, and they wouldn't do anything about it. She was asked why she didn't reach out to law enforcement, and she said that she didn't. Well, number one, that she may have spoken to a police officer about it, and then didn't know that she could come to the district attorney's office and see if there's anything that we could do about it. But it's very clear, and again, keeping this in the context of it's defendant's burden of proof, defendant put up no proof, state put up proof, and proof shows that Ms. Strawberry didn't know that the vehicle was purchased and that the defendant's the one that did it using her information. And so based on all of that, Judge, we would submit that this defendant has no standing to challenge the search of this vehicle. He procured it by fraud through at least 2 different ways. His procurement of the vehicle by fraud cannot be the basis for an expectation of privacy that society is prepared to recognize as legitimate. This court should not recognize it as legitimate, and the inquiry should end there. His motion to suppress should be denied. And if the court disagrees with that, as we've laid out in our pleadings and argument previously before the court, we also don't believe that there's any of the, well, with the exception of a few things we identified in our pleadings, that the evidence that the defendant challenges is fruit of the poisonous tree. And with that, I would take any questions the court has, but nothing further on behalf of the state.
All right, so State's Exhibit 1. I heard the testimony, I understand what it is. What's the evidence that Mr. Williams filled out this form, told someone to fill out this form and put, I understand Ms. Strawberry said, I didn't do it. How do we know that Mr. Williams did?
Yes, Judge. And again, first I'll point the court back to, it's the defendant's burden of proof to disprove this. It's not the state's burden of proof. However, circumstantially, number one thing is, he's the one driving the vehicle. And so if someone else put all this together, wouldn't they be driving the vehicle around? He's the one that's driving the vehicle around for 2.5 years between the day that all this happened and the day that he was arrested by Roswell Police Department. That's fact number one, circumstantially, that shows he did it or was an accomplice in it. Number two is the fact that, as I pointed out, all of the contact information for references, family, friends, even the contact information that's listed for Ms. Strawberry herself are individuals that the testimony before this court is that those people are accomplices of the defendant. Alasia Alexander, who goes by Dominique, is an assistant of the defendant. She's involved in some of the other crimes in the indictment. And her phone number is that one listed as if it were Shirley Strawberry's phone number, the 678-956-2629. Number two, Carlos Lamont, who's listed on here with a phone number that comes back to Earl Lamont Dunbar. As you heard, as the court heard the evidence before the court, is that's again, a known associate of the defendant. They talk on the phone while he's in jail. They talk about finances. They talk about running around doing business together. And it was described as a close friendship. And then the third, the kind of backup that Mr. Williams recently calls me put on here is his Falta Ellis reference, 404-454-5653, which again, the testimony was investigator Ansel reached out to this phone number. She stated that the person who owned the phone number said that her daughter used to use it, and she believes that her daughter is an accomplice of the defendants. And so I'll remind the court that actually, I take another step back, Judge. If you just look at the very top line of the credit application, where it lists Ms. Strawberry's name, it lists her birth date, which Mr. Williams would have access to because he's fraudulently and purportedly her husband, but he has access to her birth date. And it also lists her full social security number. We've redacted it, but he had access to it. There's been no evidence that anyone else would have access to it, but common sense tells you they're living together. She thinks they're married, and so he has access to her personal information and uses it on you. And then again, like I pointed out, Judge, I think the number one thing is that he's driving the car around, and he's, at least at the beginning, making payments on the vehicle. So I don't know why anyone else would let him drive the car around if it wasn't, and why he'd be making payments if it wasn't for him.
And so I understand in my head, what State's Exhibit 1 is the credit application. The cards, the truck, the car itself, usually they are registered in someone's name with a county, tax collector. Do we have the registration for the truck?
I believe I do have it, Judge.
And I asked the witness, when was the car put in her name, and she didn't know.
I can certainly, I mean, it's public record, so I can certainly pull it. And if the court would want me to pull that and submit it within, I mean, I can do it within the next probably 48 hours as a supplemental exhibit.
No, I didn't know if we had it somewhere and but you believe that if there's fraud in the financing application, then that's sufficient to, for a person to not have an expectation of privacy.
Judge, and it's not just the financing application, there's actually two documents in the exhibit.
Okay.
So there's the financing application, and then if you flip to about the 6th page, there's the actual retail installment contract and security agreement. That's the actual contract for the purchase of the vehicle, where the defendant binds her by contract.
All right, buyer. Okay, I see buyer's name, Shirley C. Strawberry. Understood.
And at a 28% interest rate, didn't even bother to get her a good interest rate.
Well, I was objecting to that. I mean,
Sustained. Sustained. Okay, all right. I do see it's a second document. Okay, fair. Okay. Anything else?
No, Judge.
Attorney Hooper?
yes, Your Honor. And I tried to streamline this as much as I could, so we are not here forever. First, Your Honor, may I approach with some case law?
Yes, sir.
So I'm giving the state the case law that I'm about to quote, I'm giving the court as well.
Thank you, sir.
So, Your Honor, like I said, I tried to streamline this as much as possible, but the first question that I have for the court that I'm going to address, but the question that keeps popping into my mind while I heard testimony and going over what the state's argument was number one, who exactly is the victim in this issue? So the state has well, let me back up. For starters, this all started because Officer Fields at the time committed a warrantless search on the vehicle, and the court's already aware Mr. Williams was driving illegally. There were no issues with the vehicle. It was parked. He wasn't even near the vehicle. She got in because of a faulty alerted dog, they claim. But it all started because she violated Mr. Williams' constitutional rights by searching the vehicle without a warrant or probable cause. During that hearing, the state never brings up any of this fraud, never brings up any of the big as to why Mr. Williams doesn't have standing. it was only, and I believe, I've lost count at this one, it was only, 4, 5, 6 months later that the state almost completely abandons their first argument and goes straight to, well, there's bigamy, there's fraud. But in their briefs, in their arguments, in the testimony that they presented today, I'm still having an issue of figuring out who the victim is. So if Mr. Williams defrauded or purchased the vehicle from a company through fraud, then would that make the company that he got the vehicle from the victim? Meaning if I purchase a vehicle, I don't make my payments on it, or I do something and they repossess it, they're the victims, they're the ones that take the car back. The state doesn't make that clear. So then that means, is Miss Shirley Strawberry the victim in the case because it was in her name? So if Miss Strawberry is the victim because the vehicle was in her name, which I'm going to get to, well then that kind of defeats the whole fraud issue because the company isn't the problem or doesn't have the problem, Miss Strawberry does. So there's this moving goalpost that the state literally has been jumping between this entire time. And again, this is a completely new argument from what we've been arguing for years. I mean, well, not years, but they've had the case for years, but this is the argument they've ever brought up. And I asked that, Your Honor, because there are some dates that don't quite add up. Now, during the testimony, Ms. Strawberry, okay, we know the vehicle was purchased January 2020. Ms. Strawberry said she found out about the vehicle, not that she started making payments herself. She first found out about the vehicle in 2019 or 2020. So we know the vehicle was purchased at the beginning of 2020. That's when she found out about the vehicle. She doesn't allege fraud or allege something was put in her name illegally until what she said, Mr. Williams was arrested. So that is July 7th of 2022. So between January 2020, for over 2 years, she knows the vehicle exists. She knows that her husband at the time is driving the vehicle. She's been in the vehicle herself, and she's taken no steps whatsoever to say this is fraud. And I find it interesting that even as of today, Ms. Strawberry still claims that she had no idea that the vehicle was in her name. It just doesn't make sense. Now, here's the issue, Your Honor, before I get to my case law. Ms. Strawberry, the evidence is clear. Ms. Strawberry didn't change the bank account information once Mr. Williams was arrested in 2022. What that means is from January 2020 up until, I guess now, her bank account, her personal bank account has been making payments on this vehicle. Not only has her personal bank account been making payments on the vehicle, but her personal bank account has been paying the insurance on the vehicle, and none of that ever changed. So at the point where Ms. Strawberry knows the vehicle exists, she knows the money's coming out of her personal account for the vehicle and the insurance, it doesn't turn into oh, this is fraud until later on. I have a case that addresses that when it comes to the stolen car argument that the state was bringing up, but that's really important because even after she finds out about the vehicle, and even after Mr. Williams was arrested, she said she started taking over herself. It doesn't make sense that her personal information never changed. Now, number two, Ms. Strawberry, and there's case law that I'm going to score on this as well, Ms. Strawberry never took steps to get the vehicle out of her name. Now, that's important because in the state of Georgia, there's actually laws that says if a vehicle is procured in your name, you can give that back to the company and it doesn't go against your record. If she believed, we still don't know if she honestly or allegedly believed that this vehicle was procured through fraud. But what we do know is she never, even after the divorce, she never took the steps to say, I don't want this vehicle. It was procured through fraud. Let me get a police report. Let me take it back. She does say that she reached out to Westlake Financial, which is brand new, so pretty much anyone that has anything to do with the case, and there's no evidence whatsoever of what happened. And I want to make that clear because, again, we're trying to figure out who the actual victim is, and if the person was an actual victim, what information was known and when. Now, that's really important. When it comes to the different marriages, in Georgia, when it comes to bigamy, Your Honor, the state's right that once they can prove that, let's say, an ex-wife or an ex-husband is alive, the next step is, okay, well, did the other person know about it? The issue that the state keeps glossing over is, was there a reasonable belief under bigamy? Mr. Williams had to have purposely known he was still married to someone, and he had to purposely, I hate how they use the word contract, but contract with another person to be married. There's no evidence whatsoever that Mr. Williams ever actually knew that he is or that none of his previous marriages were dissolved. And I say that, Your Honor, because it states too, when you're talking about the marriage of Miss Edith back in South Carolina, there's been no evidence whatsoever that that marriage still exists. There's been no evidence whatsoever that the marriages following that marriage were void or were dissolved because he was still married at the time. And Your Honor, we've gone over Mr. Williams' record the entire time. There's nothing that shows there's nothing that shows that marriage was not dissolved at the time we moved forward. It goes on to show that in States 3, the marriage to Miss Halliburton, again, in DeKalb County, no court of law, no office, there was no jurisdiction saying, you know what, this is wrong, we can't do this because you're married to somebody else. Again, when it comes to Miss Shirley Strawberry's marriage to Mr. Williams, again, there's nothing that says that Mr. Williams knew that he was marrying someone else knowing he was already married. Now, the state wants to tell you that we didn't put up evidence to show that he didn't mentally have the concept of it. Like, that's not how this works. They put up the evidence to show that there were 3 legally valid marriages. None of those marriages ended because one was because it was void because of something else. And the biggest part is, Your Honor, Ms. Strawberry filed for a divorce against Mr. Williams. That's extremely important because if what the state's saying is true, and if he was still married to at least one of the other women that he was married to, then a divorce wouldn't be a legally binding contract in Georgia. She would have to gotten it annulled. What's more important, Your Honor, and the state didn't want me to talk about this, but her divorce attorney used to be an attorney with the district attorney's office of Fulton County. So she understood the difference between annulment and divorce. And she's the one that Ms. Strawberry told her that he was married to other people. Now, an attorney that knows the difference between an annulment and a divorce has a client and puts her through a divorce and not an annulment, that's either she's ineffective or it's not true. And the state never put up any evidence that it's not true. Even now, the divorce has been finalized, it's been settled. The state didn't come back and say, well, she's taking the steps to get annulled now that we know this fraud happened. Or she's taking the steps to get annulled now that we know there was bigamy. The reason why, Your Honor, because they don't have evidence of it. What we have is maybe her attorney that used to be a DA told her he's married to multiple people, doesn't get any other evidence other than that, but she puts her through a legal contract of a divorce that I don't know. That's extremely important. Now, when it comes to the case law itself, Your Honor, you have all the cases as well as the state. United States v. Rubio Rivera, RUBIO-RIVERIA, 917 F2D 1271, that's a 10th Circuit 1990 case. It has the holding that where the defendant offers sufficient evidence indicating that he has permission of the owner to use the vehicle, the defendant plainly has a reasonable expectation of privacy in the vehicle and standing to challenge the search. Now, I say that, Your Honor, because at the moment Mr. Williams was arrested, we know Ms. Strawberry knew about the vehicle. We know the payments for the vehicle and the insurance are coming out of her personal account. And we know that a probable cause or a reason, underlying basis to get in that vehicle had nothing to do with fraud. It had nothing to do with vehicle. So based off of that case law, he had permission from the owner to drive it. Officer Fields even says that. I've seen Mr. Williams drive around that vehicle all the time. Moving to the next point. Now, the state quoted a lot of cases, and they talked about the stolen vehicles, or hypothetical. They specifically bring up Rackus and Stinsky. I always say that case wrong. But, Your Honor, there is a difference between Rackus and Stinsky and the cases the state quoted in regards to stolen vehicles and what's going on in front of you today. Now, United States v. Garcia, 897 F2D 1413, that's a 7th Circuit 1990 case. That case literally says the dispositive factor in Rackus, Stinsky, and Hargrove was that the vehicles were actually stolen. The defendants attempted to conceal the vehicles' true identity, and defendants did not challenge the status of the vehicles. In this case, Garcia did challenge the status of the vehicle. And the court said it's different from the case of the state was quoting because this defendant actually quote or challenged the status. Now, I say that because the cases that the state quoted had to do with, I believe, there were co-defendants, they killed a woman, stole her car, drove off. They knew one of the co-defendants was the last person around her. They saw her in the car, which matches the bolo. They knew the car was stolen. They never challenged the validity of whether or not that car was stolen. Another one, there was an armed robbery. I'm sorry, not an armed robbery. Someone stole a person's ID, rented a vehicle, went to a high-speed station, or they fled for a little bit, got arrested, and they didn't contest the fact that they didn't have that car legal. In Garcia, Your Honor, Mr. Garcia contested the fact that he didn't know that car was stolen at the time. He thought he had permission from the owner, and the court said, you're absolutely right, you do have standing. In that court, the state brought up the society's, what society recognizes. The court actually says in the rationale, if an individual has the owner's permission to use property, society surely recognizes this as reasonable. It goes on to quote United States v. Miller, 821 F2D 546, 11th Circuit 1987 case. Defendant's use of the vehicle with the owner's permission provides defendant with a subjective expectation of privacy that is reasonable and legitimate. And I believe that is extremely important because it cuts directly against the cases the state quoted in regards to stolen vehicles, because we are contesting the fact that this vehicle was ever procured by fraud. They presented no evidence whatsoever, and we'll get on that a little bit, but Mr. Garcia did the exact same thing, and that court, plus the 11th Circuit Court, since 1987, they said a person is standing if they're challenging the status of the vehicle. Now, the rental car exception, Your Honor, it was similar. I have a case for you, United States v. Henderson, 241 F3rd 638. That's a 2000 case. Now, in that case, FBI found a confidential informant. Confidential informant said, hey, I know someone that was part of this armed robbery with me, and identified the vehicle and that person. FBI finds the vehicle, impounds the vehicle, and they find in the vehicle evidence of the armed robbery. Now, the state tried to say because the rental car, the lease was expiring on the rental car. So that means that he had to turn that back into the rental company. He shouldn't have standing to challenge it anymore. What the court said in Henderson was that Henderson still had standing to challenge the search of the vehicle. The rationale, quoting the United States v. Cooper, 133 F3rd 1394, which is an 11th Circuit 1998 case, they say the 11th Circuit has held that a lessee may have a reasonable expectation of privacy in a rental car, even after the rental agreement had expired. Although the lease had expired, the rental car company had not attempted to repossess the car. Now that's similar to the issue that's before the court today, because Your Honor, Ms. Strawberry, the company where the Laurel's trucks, they did nothing, they took no steps to repossess the vehicle. That's the issue in our case today. And again, Ms. Strawberry knew the car existed, knew that Mr. Williams was driving it, knew it was coming out of her information or her personal account. She never took steps to repossess the car or take it back or do anything other than allow him to drive it. Now, the state did talk about the fact that, well, if Ms. Strawberry knew this, then she wouldn't let him drive it in the first place. She would never let him purchase it. There's a case that I believe is directly on point with that as well. It's United States v. Jeter, Jeter. That's 394 F sub 2D 1334. That's a 2005 case, and it deals with false pretenses. Facts in that case: defendant and passenger borrowed a car from passenger's fiance. They were pulled over and stopped. The passenger gave consent to search the vehicle. The government argued that defendants lacked standing. And then they found drugs in the vehicle. The government argued the defendant lacked standing to challenge the search because they obtained Ms. Floyd's permission to use the car under false pretenses that invalidated that permission. That's pretty much what the state tried to claim today, without any type of other evidence other than they say it, because Ms. Strawberry never said that. However, the holding in this case is the defendant had the standing to challenge the search. The rationale: if accepted, the government's expansive position would bar defendants from challenging a wide range of government searches. The implication of their position would not be limited to simply cars. In many other situations where a defendant is in possession of property by permission of another, the government could argue that possession was obtained through false pretenses, and therefore the defendant could not challenge a search. They go on to give examples about a homeowner and mortgage and a couple other examples. They move on to say the situation of property being obtained by a defendant under false pretenses should be distinguished from that in which the defendant never legitimately obtains property. So the issue is the cases that the state continues to bring up, they never legitimately retained the property. Yes, there was no question at all that these vehicles were stolen. Yes, there was no question at all, and I do have a case about the hotel we're going to talk about in a second, but yes, there was no question at all that not only did they find out that in the cases about the hotel, that fraud was used, stolen identification was used, something was used, but they actually took steps to get the person out, aka evict the person. The problem is the state never showed that there were any steps taken because there weren't. Your Honor, this is literally just, it equates to, Ms. Strawberry tells you, we know the car, she knows the car exists. She knows the car is coming out of her personal account because that never changed. She knows the insurance coming out of her personal account that never changes. Mr. Williams drives a vehicle with no issues, that never changes. All of a sudden he gets arrested, now there's a problem. There are a lot of cases that, in Georgia that are quoted that same thing happens. Somebody lets someone borrow a car, they get arrested. Oh, now I'm going to report the car stolen because I'm trying to distance myself from him. That is exactly what's happened here. The state has to prove it otherwise. Now, in regards to the hotel example that they kept giving, case law is clear on that as well. U.S. v. Batista, B-A-U-T-I-S-T-A, that's 362 F3rd 584. That's a 2004 case. In that case, the defendant was in the hotel room making counterfeit money. A representative from the booking agency called and told the hotel manager that, hey, the card that was on file was stolen. The manager calls the police. However, before the manager tried to evict the defendant, police went in and searched it, saw the counterfeit money. The holding in that case, the defendant retained a legitimate expectation of privacy at the time of the warrantless entry by police. In this case, neither the motel's manager nor the police had reached a conclusion that the defendant had fraudulently procured the room. The manager did not ask the police to evict the defendant, and the police did not suggest doing so. Neither the motel manager nor the police knew whether the defendant had obtained the room by fraud. No investigation had yet been conducted, and no cause for rejection had been developed. The defendant still had 2 days remaining on his reservation, and the motel had taken no affirmative steps to repossess the room. So not only, case is almost right on point with us. The day Mr. Williams was arrested, there's testimony. Not a single officer believed that that vehicle was procured by fraud. The day Mr. Williams was arrested, Ms. Shirley Strawberry never filed a report or took any steps to say that vehicle was procured by fraud, I need to get out of my name. The day he was arrested, even though she knew about it, no steps were taken, no investigation happened. At that point, Mr. Williams was legally driving that vehicle. And what the state still never brings up is that he wasn't even in the vehicle when he was arrested. He was, half football field away. That's extremely important. No steps were taken, no investigation was done, it was not a precursor to get into that vehicle, there was no underlying basis to show probable cause, it did not exist at the time. Now, using the state's own logic, the state's own rationale, they failed with the stolen car argument and with the hotel argument because it needs to be more. If we're contesting it, it needs to be more. Now, in regards to diddy, there is a part of OCGA 1662 that says that the person it shall be an affirmative defense that the prior spouse has been continuously absent for a period of 7 years, during which the accused did not know the prior spouse to be alive, or that the accused reasonably believed he was eligible to remarry. In regards to states too, Your Honor, you can tell that, or you can see from the state's own evidence that Ms. Edith took the steps to find Mr. Williams. They just didn't locate each other. That's what took so long. But at the point where Ms. Edith didn't know where Mr. Williams was, she was still granted a divorce. Everything was good, and that was never revoked. No one ever came back and said that's not true. And Mr. Williams didn't know because he was never served with anything at that time. He didn't know that it was happening because they couldn't find each other. So the state now has to move to that he reasonably believed that he was eligible to remarry. Well, the evidence shows he was because he remarried in DeKalb County to Ms. Halliburton. There were no issues. He remarried to Ms. Strawberry after Ms. Halliburton. There were no issues. So he reasonably believed that he was eligible to remarry. Now, to discuss this a little more, there's a case, I have to spell it, Dillard v. Schilke, S-C-H-I-L-K-E. That's a 352 Georgia Act 158, it's a 2019 case. The rule from this case is very simple. Subjective beliefs as to marital status of husband and wife are irrelevant to determination of whether husband's first or subsequent wife was husband's lawful wife at the time of his death. In this case, he had died, they're trying to argue who was the wife. The biggest thing here is, Your Honor, the only testimony that the state presented was literally subjective, it wasn't even subjective belief, it was hearsay from her attorney, which knew better because she knows the difference between annulment and a divorce. So that case is right on point with, there's no evidence that Mr. Williams ever knew or intended to defraud, or intended to get to a marriage with Ms. Strawberry, reasonably believing that he was already in a marriage with somebody else. Robinson v. State, that's 6 Georgia, Act 696. I mean, this has been good case law since 1906 here in Georgia, Your Honor, where accused honestly believed that his first wife had secured a divorce, and this belief was induced by reasonable diligence to ascertain the truth. Inference is authorized that he had no criminal intent in entering a second marriage and was therefore not guilty of bigamy. Your Honor, the testimony shows that not only did law enforcement, not only did an investigator from the Fulton County District Attorney's Office look into all of this, he couldn't find where Mr. Williams was still in a marriage with somebody else. And they literally have the power of the state. If a person in that position couldn't find it, then it's a reasonable belief that Mr. Williams believed that he was free to marry. Everything showing that he literally married Ms. Strawberry, and the way their final divorce ended even solidifies the fact that's a reasonable belief, and the state never presented otherwise. There's another case, Longstreet, Longstreet v. Longstreet, 205 Georgia 225. This is a 1949 case. Again, this law has been good since 1949 here in Georgia. The assumption as to the validity of the second marriage can be negative only by disproving every reasonable possibility. The state does not prove every reasonable possibility. They go on to quote, that's a quote from Brown v. Parks, 173 Georgia 228. We'll move on from this because I don't want to beat this dead horse. In regards to, there are a couple cases I want to quote, but I'm not going to read from all of them. The first one is Gerlach v. Odom, Gearllach v. Odom, 200 Georgia 350, a 1946 case. Ray v. Dooley, Dooley, 200 Georgia 811, a 1952 case. Beard v. State, 285 Georgia 675, 2009 case. Since a marriage status has never existed between the parties to the suit and the defendant has never been the wife of the petitioner, it follows that a suit for divorce will not be an available remedy to the petitioner. That's important, Your Honor, because what this says is, if it was actually true, if he was actually married to somebody else, and Ms. Strawberry and her attorney actually believed that, then a divorce would not be sufficient in Georgia. They would have to get annulment. Her attorney knew that because she was a prosecutor at first with this office, and now she's doing divorce law. Her attorney knew that, and this, in all of these cases, cut against it. There was no existing marriage that could be the subject of a divorce. There was no testimony that ever was, because there was an actual divorce every single time, including with Ms. Strawberry. And even when she claims she figured all of this out, she still hasn't taken the steps, and neither has the district attorney's office. Also, my last case, or last group of cases I wanted to quote, Campbell v. Allen, 208 Georgia 274, 1951 case. Ray v. Dooley, 208 Georgia 811, 1952 case. Park v. Ziegler, Ziegler, 224 Georgia 144, 1968 case. And Wright v. Hall, Wright v. Hall, 292 Georgia 457, 2013 case. If a final decree of divorce has been entered with respect to an invalid marriage, the decree may be set aside as void. That is not happening. The reason why it's not happening here, because there is no bigamy in this case. The state has presented no evidence whatsoever. Ms. Shirley Strawberry had an attorney that was in the best position to understand that, to know that, and effectively communicate that not only to Ms. Strawberry, but to the court as well, and it never happened. They still haven't taken any steps. So again, the question is, who is the actual victim here? Is it the mortgage company? Well, the answer is no, they haven't shown that. Is it the company, Laurel's Trucks, that actually the physical building where he purchased a vehicle from? The answer is no. Ms. Strawberry, the answer is no. The testimony shows you that she only tried to distance herself from the vehicle, and Mr. Williams was after he was arrested. Not when she found out about the vehicle, not when she got when she figured out the money was coming out. She only did it afterwards. And even when she did it afterwards, she really didn't, because she didn't change any accounts. Everything was still coming out the same. She didn't say this was fraud, everything was still the same, and she kept it in the divorce, Your Honor. For all of those reasons, make sure they listen to me. Yes, Your Honor. So at the point where none of this information was known by any law enforcement or the DA or anybody at the time of the arrest, no steps have been taken, no investigation have been done, that have actually produced some evidence that Mr. Williams defrauded anyone for anything, or that this marriage was bigamous. I do not believe the state has met their burden. And again, Your Honor, the state did give you states 1, 2, 3, 4, and 5. And in these, they talked about how there are certain phone numbers for certain people, there are certain email addresses for certain people, but they never showed you how that was some type of fraud. That's the problem. The state never tells you where the fraud comes from. They never tell you who the victim is because there isn't one, because it didn't happen, and they did not prove the elements of bigamy. And for those reasons, Your Honor, we're asking that you go back to the beginning when we first argued, and Mr. Williams does have standing. They violated his constitutional rights under the Fourth Amendment, and the evidence that we're asking to be kept out should be kept out. Thank you.
Understood. Anything?
Yes, Judge, I just want to hit a few points. Just a few counts. First, there's an argument that we never brought this issue up initially. But the reason we didn't bring it up initially, this standing issue up initially, the reason we didn't bring it up initially is because it's their burden to prove it. And so we're not going to come into court and tell you, like, hey, you need to prove this to win. We didn't bring it up because they didn't prove it and they put in no evidence as to standing. And so we realized that and brought it to the court's attention, and that's why there was so much delay. And in any case, the court explicitly said that we could provide additional briefing. So the second thing is there's the theme that I'm hearing of the argument is who is the victim in this case, or in this situation. And let me be very clear, the victim is Shirley Strawberry. She's a victim of identity fraud. She's a victim of bigamy. She is the victim. That's unequivocal. So if there's any question there, that's the answer. There was an objection raised that Ms. Strawberry didn't, that Ms. Strawberry knew that the vehicle existed in 2020, and therefore there couldn't have been fraud. Well, her knowledge of the vehicle existing in 2020 is not contested. The state brought out that evidence. The question is, when did she find out that her information had been used without her knowledge? And she testified that that was in 2022 after the defendant was arrested. So I don't think there's any relevance as to the fact that she knew the vehicle existed. We're not contesting that fact. There's an argument that where's the evidence that Mr. Williams knew that the marriage to Ms. Strawberry was bigamous? Number one, I go back to where I began at the beginning of my argument. It is the defendant's burden of proof on the question of standing. So it's the defendant could have testified, I didn't know, or I thought my first wife was dead, or I thought we had a divorce. So they didn't establish any of those facts, number one. Number two, how do we know that the defendant knew about the marriages, or about the previous marriages, and the existence of them? Well, we know if you look at State's Exhibit 3 and State's Exhibit 4, where the defendant lied on his marriage license application. And we know that. State's Exhibit 3, he says that he had 0 previous marriages, when he absolutely had a previous marriage to Ms. Miller. So lie number one. And then if you look at State's Exhibit 4, where the defendant says he had 3 marriages, but says that each of those 3 marriages were dissolved by divorce, that's lie number 2. We know that that's not the case because the marriage, at least to Ms. Halliburton, is not dissolved by divorce until December 29th of 2021. That's State's Exhibit 5. And the document where he lies and says that the marriage was dissolved by divorce is from December 16th, 2014. So you take the 2 lies in the 2 marriage license applications and provide some pretty good circumstantial evidence that the defendant knew that these prior marriages existed. Otherwise, why was he trying to conceal them through lies? Additionally, there's been a lot of argument and even a lot of case law on this distinction between divorce and I would start with number one that has no relevance to the issues here. What a divorce attorney did in a divorce proceeding has literally no relevance to what's going on in this courtroom. We've put up the evidence that the marriages were bigamous. We've put up evidence that the circumstantial evidence the defendant knew that the marriages were bigamous based on his prior lies in his marriage license application. And then number two on that issue, and I would ask that the court just indulge this because I know the answer to the question, and I would make the representation as an officer of the court that I watched those hearings, those divorce hearings, and what happened was the judge in the divorce said, well, hey, based on the bigamy and the void marriage, don't you want an annulment? And the response was, well, we've already initiated the divorce proceedings and we want to just get this over with and we're already here, so let's just do it this way. Now, I'm making no comment as to whether that's proper at all, but this idea that the annulment possibility was never brought up, number one, is not true, and number two, just has no effect on the standing issue. There's also an argument that what the state has proven as it relates to Exhibit 1 and the false information, what we've shown is lies but not fraud. Well, if you go back to the basic definition of fraud, fraud is a lie with the intent to gain some property or some other, to gain something. So we've shown the lie, which is all the fake information on that application, and we've shown the gain, which is the truck itself. There was also, I think, an argument that Shirley Strawberry never said that fraud was committed. She testified, Your Honor, that she told a police officer when she found out about the fraudulent purchase that fraud was committed. She testified that she told the financing company that there was fraud in the purchase of the vehicle and they wouldn't do anything about it. And then she said that if she'd known that she could have brought it up to the DA's office, she would have. And then once we brought her the documents, she said, oh yeah, that's definitely fraud. I would also just distinguish a couple of the cases that were brought up. First, the 10th Circuit case, United States versus Rubio Rivera, 917 2nd 1271. This is the case that talks about if a person has permission to use a conveyance, they therefore have a reasonable expectation of privacy. That is true with an asterisk, the asterisk being if it had legitimate permission, if the person who gave them permission with the full knowledge and understanding of the full set of circumstances beyond the request to possess the property. So number one, there was no evidence, again, going back to the beginning, their burden of proof at standing, there's no evidence that he had permission to use the vehicle. With Ms. Strawberry having a full understanding of the situation, being the bigamy and the identity fraud, number one. And number two, our cases support this exact proposition, which is that, yes, when you have permission to use a conveyance, to be in a residence, to be in a hotel room, that you do have a reasonable expectation of privacy, except when you obtain that permission or procure that permission by fraud. So you look at any of the cases that we cited. When the person who had the laptop computer that they bought with a stolen credit card, did they have permission to carry that computer out of Best Buy or wherever? Yes, of course they did. But was that permission legitimate? No, because they used a stolen credit card. And so I don't think that this case is at odds with anything that we presented. Also, I would just distinguish United States versus Jeter. That's a district court decision, so it has no binding effect on this court. It's out of Utah, and so I would ask that the court not give too much weight to that case. And with that, unless the court has any questions, that's all I got.
Okay. Yes, sir.
I would just ask the court to read the cases, especially ones I quoted, because what the state has said is not what those go for it. Not one of them says where there's an asterisk. So please read the cases around. You'll see how the cases the state quoted are completely dispositive of the issues that we have here. And I think mine
All right, there you go. Thank you all. I'm going to venture to get a order out as soon as possible. I will have the order emailed to both parties. I think if I find that, you know, the state has shown that there's no expectation of privacy, and that the defendant lacks standing, Attorney Hoover, if you want to appeal, let me know. I'll give you a certificate of immediate review. I believe if I find that that they do have standing, then I think the state has an automatic right to appeal. So I will get an order out, email it to both of you, so you all know how much time you have if you want to appeal. All right, thank you all.
Thank you, George.